Okay. And hopefully the judges will be here in the next few minutes. Ladies, no JAs, yeah?
No, we haven't.
That's fine. Yeah, but we squeeze one in one corner. Oh, my glasses completely skew up.
Yeah, if you've got a mark.
My
Yeah.
optician gave me a special.
As long as they're equal distance.
Yeah.
Two of us.
Yeah.
But it actually stops it steaming up. Which is
technology.
So next time you're in a
Councillor, are we all ready?
Then I think I need to live on my own.
Yes.
I can't cope. Looking at a friend from school, went to school with me.
Ladies, the courtroom is ready whenever the judges.
Thank you.
Okay, don't worry.
they will come in on
All rise.
Here, there's a matter of ClientEarth, State for Business, Energy, Industrial Strategy, and another.
Lord, I appear with my learned friend
Yes, Mr. James.
Merrow Golden for ClientEarth, the appellants in this matter. Learned friend Mr. Andrew Tate, Queen's Counsel, with Mr. Ned Westaway appears for the respondent, Secretary of State. Learned friends Mr. James Strawn, Queen's Counsel, Mr. Ned Westaway appear on behalf of the interested party.
Yeah. I can tell you that we have read the judge's judgment.
Yes.
We have read the Secretary of State's decision letter. We have read the skeleton arguments, which are very full. So you can take those as read, and we don't need to be taken through the written skeletons.
I'm grateful to your Lordship. What I was proposing to do then was first to take your Lordships to the statutory framework at tab 4 of the Authorities Bundle, the Planning Act, and by way of preliminary observations, make some submissions on that. I was then proposing to go to the decision letter, then briefly the guidance, and then go to the grounds. But I may be able to truncate that in the light of your Lordship's observations. But I would like to go to the, I think it works with what your Lordships have said. I'd like, if I may, start with the Planning Act, because some of the grounds and submissions, obviously, particularly in respect of ground 3, but also the understanding of the function of the policy we submit, need to be understood. Obviously, in the context of the Planning Act, which your Lordship should find at page 14, tab 4, and some sections I'll take much more shortly. Your Lordships will be familiar, I know, with this Act. The framework provided for the making of national policy statements, and that's section 520, page 26. And I don't read any of that out, but I make the following observations. That the national policy statements, section 5.1b, can vary in types of their specificity, and we'll see in the various judgments different types of MPS, and I know my lords have had cause to give judgment in respect of some of those. They are subject to sustainability appraisal, and they go through the statutory process. Subparagraph 5, page 27, sets out may, and it's put in the permissive, may in particular, and then sets out a series of matters. Again, I won't read, but your Lordships will be familiar with certain MPSs focus on more or one or other of those criteria. Some set location criteria, some can be in relation to a specified description of development, and others, for example, 5B, may also include criteria for location, and C, which is particularly relevant to this case, set the relative weight to be given to specified criteria. But your Lordships will see, for example, other policy statements can deal with things such as identifying one or more specific locations as suitable or potentially suitable or unsuitable. And I flag that up not because this EN1 does that, but because when we're looking and seeking to apply other authorities,
or the Thames Tideway Tunnel, for instance.
Thames Tideway Tunnel, yeah. When we then look at 1047, section 1047, which we'll come to, as to the competitive submissions between the parties here, as to what is open to the decision maker to take into account and what is not. In other words, the extent to which an MPS may shut off considerations or not under 1047. And so obviously when looking at the particular authorities, it's our submission that one has to obviously bear in mind the context, and by reference to section 5.5, the particular criteria or elements which the particular MPS is dealing with. So section 6, again, it's the point that we'll come to in the authorities, is the review mechanism. It will be our submission that it's no part, or it is our submission, of section 208, that section 6 is intended in some way to cut down, for example, 1047. So in other words, the suggestion that an MPS, whatever the circumstances, cannot be questioned, or more particularly the benefits and adverse impact cannot be weighed in a different way under 1047 because, for example, taking into account that the MPS may in some way be dated, because there's a review mechanism. And we just make a few submissions preliminary on section 6. There's nothing in section 6 that says that it ousts or in some way impacts on the plain wording, we say, of 1047. But when one looks at section 6, my lords, I just take it very, again, curious piece of drafting in our submission. The obligation is at 6.1, such as it is, the Secretary of State must review each MPS whenever the Secretary of State thinks it's appropriate to do. So you start with an obligation, and then it's then expressed to be up to when the Secretary of State considers it appropriate to do so. And it may relate to all or part of an MPS, and then subsections 3 and 4 effectively duplicate for a review in relation to the whole of an MPS or the relevant part of an MPS, the same factors. In deciding when to review a national policy statement, the Secretary of State must consider, and then there are a series of factors which are duplicated at 3 and 4. So, for example, whether a change was anticipated at the time, whether there's been any change in circumstances. And then 5 is the obligation after completing a review. So the first bit is when do you have to review? Second bit is after completing the review, well, you've got an obligation, but it's to do the only 3 things you could do: amend, withdraw, or leave the statement in place. So, I mean, it's a complete range of discretion. What we say in respect...
It might have been limited below that, presumably.
Oh, yes, my lord, yes. You must carry out a sustainability appraisal, and there must be consultation, and then you must obviously go through the parliamentary procedure. But that's quite right. But in terms of, it's kind of curious because yes, but in terms of the options that are open. But could I just go back briefly to the review section 6? It doesn't say, and there is a pending case, which obviously that there is a judicial review of this policy by other parties, which is, I think, has been postponed. But neither subsection 3 or 4 says, having taken those matters into account, you are then obliged, as a Secretary of State, to carry out a review. On the face of it, the Secretary of State has a discretion whenever the Secretary of State thinks it's appropriate to do so, but when deciding that, you must consider those factors. But the statute doesn't prescribe an outcome based on the...
No. But I mean, your overarching point, as I understand it, is that Section 6 does not cut down the balancing exercises under Section 1047.
My lord, yes.
Do we need to know anything more about Section 6? Because otherwise it doesn't seem to me to feature in this appeal.
Well, my lord...
The point that was being made, or put against you, was that because there was a review machinery under Section 6, benefits or otherwise of the policy couldn't be questioned on the application for the development consent order. And you just said, no, there's nothing in Section 6 which cuts down Section 1047. But do we need to get into the intricacies of Section 6?
Well, my lord, in my submission, no, but I didn't succeed on that argument below on the simple propositions that I made, so I've sought to advance it. But
well, wait and see what your opponents say about it, and if necessary, you can reply on it.
My lord, yes. Could I then briefly just go to Section 10 and just note, and of course this is not a challenge to the policy, it must therefore be assumed that in adopting the policy that has been adopted, EN1, that 10 subsection 3 has been complied with, given that there was no challenge, and that's simply the Secretary of State has to have regard to the desirability of mitigating and adopting to climate change. I just we make that point in passing when we come on to the grounds 1 and 2 on the interpretation of the policy. My lords, I don't make any submissions on Section 13. My lord, the next point is Section 87, but that's dealing with the examining body, and the same submissions really apply to Section 106, matters that may be disregarded when deciding the application. So can I just start with Section 106, which is directed at the Secretary of State and duplicates Section 87 3, which deals with the examining body. So again, our submission that 106 gives a discretion to the decision maker in the examining body to disregard the matters set out A, B and C. So what that means in our submission, and this is relevant to the arguments that talk about pragmatism and what was intended by the Act to stop people taking time at examinations, that these arguments are up for grabs, if you like, unless and until not just the examining body, but also the Secretary of State exercises the appropriate discretion. So, as your lordships know, there's a number of two-stage processes, but in terms of the process that the Neighbourhood Planning Act brought the Secretary of State back into play, so the examining authority simply reports to the Secretary of State, as they did in this case. So, what do we say about those three and the significance? Well, there's vexatious, frivolous, there's a merits of the policy set out in National Policy Statement, and then there's relate to compensation. It's B that I wish to just make a brief submission on at this stage. If you can make, if there is a discretion, and a discretion, it's a trite public law, if you've got a discretion, you've got a duty to exercise it, particularly if someone makes a submission on the merits of the policy. The Act allows the Secretary of State or the examining body, therefore, to disregard or to have regard. But then that needs to be read, obviously in conjunction, in terms of the merits of the policy, to when we come to the actual decision making, and I'd ask your lordships to go to Section 104, page 47 of the statutory bundle, and that sets out what the decision maker has to take into account where there is a relevant NPS in effect, and there's a 104 2D, which I'll come to later, just simply any other matters which the Secretary of State thinks both are important and relevant to the Secretary of State's decision. So there's a wide discretion there to the Secretary of State. But I just want to pause with that and staying with 106, then go to 104.3, because 104.3 says the Secretary of State must decide the application in accordance with any relevant national policy statement, and then except to the extent that one of the subsections 4 to 8 applies. Now, pausing there, if the sentence had stopped must decide the application in accordance with any relevant national policy statement, it's difficult to see then how 106B could ever operate, because by definition, if you decide it in accordance with the relevant policy, and if the sentence had stopped there, there would be no possibility of the Secretary of State ever exercising the discretion under Section 106 to not to disregard the merits of the policy. And therefore, in our submission, the merits of the policy, that discretion, arises in the exceptions, because you could have, for example, merits of a policy which someone challenges on the basis that they're unlawful or they're out of date or all sorts of things. And it seems to us the only way that that merits challenge can come in is through one of those exceptions, because otherwise you've got that conflict with 104.3.
There's a difference between challenging the merits of a policy, isn't there, and deciding an application in accordance with that policy, subject to exceptions. There's no...
Yes, my lord, they're not the same.
They're not the same concept.
They're not the same concept, no, my lord. And we rely primarily on the exceptions, as we did in the court below.
Yeah.
But in trying to understand how the section works, the statutory procedure works, I've been asking myself, how does 104 1B, how can it possibly work? And the problem I had...
So, I mean, are you saying that going to section 104.7, that the adverse impact of the proposed development can include flaws in the policy itself, which the Secretary of State has regard to under section 106? Is that the point?
It supports our primary submission. It's a subsidiary submission. Our primary submission, as my lord put to me earlier on, is that 104, not only is 104.7 not limited by section 6, in essence, we say the presumption, and there's some authoritative support for that, the presumption and the weight that goes to factors in the policy is taken off when you go to section 104.7, and you ask yourself a different question. Simply the adverse impacts the proposed development would outweigh its benefits. My submissions to your lordships on 106 are very much a secondary submission to our principal point on statutory interpretation, that 104.7 is not cut down and is not read with policy on.
But your case, as I understand it at least, is founded on an interpretation of the policy in EN1, not on any challenge to the merits of the policy itself. So you take the policy at face value as you would have us interpret it, and you say that the Secretary of State erred in certain respects in applying the policy properly construed.
My lord, what we say, grounds 1 and 2 are on the basis of are predicated on our interpretation of the policy. Ground 3 stands even if we're wrong on that, because we say the Secretary of State misapplied her approach to 104.7, and so grounds 1 and 2, my lord, yes, are predicated that our interpretation, the N1, is correct. Ground 3 has always been an attack on the approach to 104.7. All I'm saying about 106B is a subsidiary point in support of what would be our ground 3 point, is that you don't carry through the presumption in 104.3 to 104.7. So in other words, you determine the policy. So if we're wrong on grounds 1 and 2, the Secretary of State has determined the policy, and then 10047 requires a test to be applied, which is that the adverse impacts of the proposed development outweigh the benefits. It's not a test, for example, my Lord Justice Limbaugh and others will be familiar with, for example, the green belt test. If you're inappropriate development, you won't be granted consent unless very special circumstances outweigh. So it's a departure from policy. And again, as when we come to the decision letter, the approach taken by the Secretary of State, we say, is that she simply says, we'll come to the decision letter, I know you've read it, but it doesn't follow a logical approach of first determining the MPPS, then setting out the exception, and then setting out the exceptions test, seeing what the outcome of 1047 is, and then deciding what to do. What we're told is the Secretary of State sees no reason, and we'll come to what Pricey says, to depart from the presumption. And that, we say, is a misunderstanding in ground 3 of 1047, because it's effectively saying you're looking at a departure from policy rather than applying 1047 that sets a specific statutory test for when the policy, you're no longer obliged to follow the policy.
Well, subsections 3 and 7 interact clearly because they're connected explicitly in 3. So the exercise that you undertake as relevant under subsection 7 must find its place within the overall context of an application of subsection 3, mustn't it?
Yes, you start with subsection 3. There are 2 stages to it.
Well, there may be, yes, yeah, but they're integral.
Or maybe more.
They're integral to the same exercise. I mean, when representations are made which go to 7, subsection 7, then the decision maker must grapple with those representations if they're admissible representations. Arguably, see section 107, 106 rather, in considering whether that is an exception that is made good within the context of subsection 3.
My Lord, subsection 3 expressly refers to and is limited by the extent of the subsections 4 to 8. So that the first stage, we would say, is you decide whether you're in accordance with the relevant MPS. Mm-hmm. Then you then have to then accept to the, and you see it's the exception is to the obligation to decide the application in accordance. And so the exception is the way in which you approach any exception is set out, we say, in the statutory exceptions 4 to 8, and you go through each of them. So that obviously, depending on how many exceptions in play, how many sort of mini decisions or resolutions you have to make. But in terms of subsection 7, it isn't. Our submission is that it is not precluded, it's not limited by an obligation to disregard any merits of the policy or reapply the policy. It is not a standalone test in the sense that obviously it's accept to the extent, but it is a test that must be applied in accordance with the statutory wording, without other gloss.
If you look at the wording of 7, I understand your point in relation to adverse impact, but would outweigh the benefits of the proposed development. The benefits of the proposed development is that it makes a substantial contribution to the established need for electricity generation by fossil fuels, to which substantial weight must be given. The benefit has been identified, hasn't it?
My Lord, no. The compliance with the policy we accept is a benefit, but the benefit is not a reapplication of the policy. So in terms of weight that may be given for policy purposes, or indeed if we're wrong on grounds 1 and 2, those matters which are excluded, if we're wrong, greenhouse gas emissions as a reason for refusal, if we're wrong, my own friends say those are not capable of being reasons under the policy of refusing a consent.
I understand that in relation to greenhouse gas emissions, as I said, because you're talking about adverse impact. But when you're talking about the benefits of the proposed development, the benefits surely must be that which the policy is assigned, that it makes a substantial contribution to the need to generate electricity by means of fossil fuels. What other benefit is there? There may be others, but that must be part of the benefit, surely.
Our submission to your Lordship's question is, number one, the benefit is compliance with the national policy, but it isn't then, and then you then decide what weight you give to that as the decision maker. So I'll give an example why you wouldn't necessarily carry forward the various internal presumptions and weighting. For example, you come to the MPS and it complies with it, but the MPS is out of date. It's drafted for meeting a target of 80%, and net zero is now the statutory test. It has other faults. It has other things that it said it was predicated that things would be done and they wouldn't be done. It's said that it would be reviewed and it's not. So the benefit is compliance with the policy, but the weighting as to how much weight you give to that benefit is a separate decision. So under 1047, the Secretary of State weighs up the benefit unencumbered. The Secretary of State may choose to give great weight to the compliance with the policy, but the Secretary of State would be entitled to hear submissions and give less weight, for example, because it's out of date. And that's how we previously got into the arguments about you can't raise the issue of being out of date because you just have to go persuade the Secretary of State then to persuade Parliament to update the policy through the Section 6 review procedure. So even if the Secretary of State decides to lay it before Parliament, that doesn't mean it's going to be adopted. So, so our primary submission on the meaning of 1047 is that it is applied in the statutory wording as it is. And my Lord, Lord Justice Lewis makes the point, it is interesting to see the wording that is chosen. It's satisfied that the adverse impacts of the proposed development and its reference to the development would outweigh its benefits. And I'm not sure I've debated it internally whether or not anything meaningful changes out of it simply saying whether the disbenefits outweigh the benefits. But for what the statutory draftsman has taken to focus on the adverse impact of the proposed development would outweigh its benefits. Its benefits, we say, in terms of policy, are they can have, bringing jobs, other things, compliance with the policy, all the normal things. But compliance with the policy is a matter that its weight isn't prescribed in our submission.
It's a matter for judgment for the.
It's a matter for judgment.
Yes, and ultimately, when we look at the decision letter, perhaps quite soon, we'll look at that balancing exercise. Yes,
my Lord. I fully appreciate if your Lordships then are with me on 1047, but then say, well, that's what the Secretary of State said. It's not our submission. Then obviously I lose, because even if my learned friends are wrong in the statutory scheme, if the Secretary of State, the decision maker, took that decision.
James, I wasn't seeking a concession.
No, I'm not. I'm
identifying our work today.
Yes, it is.
That's what we have to look at,
yes,
within the framework set by these provisions.
My Lord, yes.
Yes.
So you are saying, I think your word was the Secretary of State conducts the balancing exercise unfettered. So you say that the significance of the policy is simply that it is a benefit. Compliance with the policy is a benefit. The weight to be given to the benefit will depend on a whole host of factors, such as whether the Secretary of State thinks the policy is out of date or whatever. How does that give effect to the instruction in section 104.3 that the Secretary of State must decide the application in accordance with any relevant NPS except to the extent that one or more of the exceptions applies? I mean, because if it's an unfettered balancing exercise, what's the point of section 104.3?
Well, the point is that the Secretary of State, so the policy, the NPPS, is drafted as it is. The Secretary of State, what's the point of having the exceptions? The exceptions allow the Secretary of State to take a step back. So let's have a look at this particular circumstance. The Secretary of State is the decision maker. This policy isn't the policy of this current government, as it happens. And you could have a circumstance where the Secretary of State has not been able to change the NPS for whatever reason, not been able to get it through Parliament, or there's been a change in the view of the Secretary of State and the government as the weight of policy, but the process through which any change has to go in the NPS is slow and laborious, or you can't get it through.
But
sorry.
I'm sorry, Mr. Jones. Just forgive me for cutting in, but it may help you in answering my Lord's question. The balancing exercise that we're contemplating at the moment is a balancing exercise within subsection 7. Within subsection 7.
Yes.
Yes, that is clearly a balancing exercise.
Yes.
The language is outweighing. So that balancing exercise, once engaged, has to be undertaken. And once it's undertaken, the Secretary of State comes back, as it were, to section 104.3 to decide whether subsection 7, or to record, as it were, in the decision whether subsection 7 applies. If it doesn't apply, then under 3, he or she must decide the application in accordance with any relevant national policy statement. Now, so far so good. Taking up your point about policy moving on, or thinking moving on.
Or Secretaries, the government changing.
Or very well, but having a different approach to energy, and so forth. Would that come in under 7 potentially? That's to say, the adverse impacts might include prejudice to current theme of government policy generically, if you will, on climate change, for example.
My Lord, yes.
So that it's not a completely forlorn hope in the situation you contemplate in your answer.
My Lord, yes.
That's what you submit, is it?
Yes.
That it can come in through there.
Yes.
And find 7 balance is satisfied in that direction, and therefore that gets you out of 3.
My Lord, yes.
That's your submission.
That's my submission. That's obviously we focused a lot on greenhouse gas submissions. That's the example, and of course, the section actually has arguably more than two. It has more than 2 stages. Now this may be a point that can cut. This is a point that could cut 2 ways for me. But this is what submission is. Your subsection 3 imposes an obligation to decide in accordance with the NPS. Then you've got the exceptions that take you out of it. So let's assume, for example, now there are 2. 104.7 is different to some of the others because some of the others well, they deal with international breaches of international law, breaches of other law. Take the international law, leave it to one side. But one would normally assume that if one of the exceptions that found that to decide in accordance with the relevant MPS would put you in breach of the law, the Secretary of State would inevitably refuse consent. Now that may be an extreme example, but it seems to me this is the point where I said it can cut both ways. But in our submission, the Secretary of State never went through this decision-making process. If you take 1047, you could find that it might be difficult to see how rationally you could come to this conclusion. But if you find that the adverse impacts of the proposed development outweigh the benefits, you're freed from the obligation to decide in respect of the MPS. But the statute doesn't say what you must then do. I mean, it would be assumed in our submission that rationally you would refuse. But I do accept that there is no express wording that would say you must then refuse consent or whatever.
No, because the Secretary of State retains the decision-making
My
discretion.
Lord, yes.
There may be other factors. It's difficult, I agree, to contemplate what they might be once you've done the subsection 7 exercise.
Yes.
Because that would probably be holistic. But the Act doesn't dictate the decision in all circumstances.
My Lord, that's right. That's our submission. And
As
when
I've understood it, sorry to cut across you.
Yes.
You're saying not simply that other factors outweigh the benefits. You're saying that the value of the benefits can be reduced. In other words, the Secretary of State could say, I am not going to give substantial weight to the fact that this contributes to the need for fossil fuel. You're saying the Secretary of State can say, I'm giving less than substantial weight, rather than that something else outweighs that substantial weight. As I understand it, you're saying the Secretary of State can reduce the value to be ascribed to the benefits.
My Lord, yes. And of course, in my submission, that must logically follow, because otherwise one engages in what sometimes can be intellectual dishonesty. Because what you then say is, oh, I still give substantial weight to this policy, but now that things have moved on, I give greater weight to greenhouse gases or something like that. So in our submission, the more appropriate course, and what we say the legislation says is it is open to the Secretary of State to give less weight. And as my Lord Justice Limblom put to me in questioning, if the holistic nature of government policy has moved on, it may very well be that they give less weight to what we say is the backup during the transitory period of the move to a low carbon energy climate, and to, for example, the considerable weight or whatever given to certain types of fossil fuel backup for energy security. And that could follow over a passage of time when, if consents come forward, for example, and are setting aside whether they're the issue of whether they're assume they're implemented, one sees that there is more nuclear, there's more renewables, and there's already more backup material. The Secretary of State will think, not just my thinking on greenhouse gas has moved on, but the facts have moved on, and therefore I give less weight to circumstances, to things that the policy would otherwise tell me.
That may be one reading of what the policy does. So that if you have now satisfied your need for renewables, whatever it is, then the proportionate weight that you give to this project is less, because it's not making much of a contribution, because you've got the contribution from all sorts of other sources. So that may be within the policy. You don't need necessarily to get it out of the Act.
My Lord, if we're right on ground, I think it's ground one, that's what we're effectively we're saying. that just as there is a qualitative weighting, there is inevitably, because of that part of the policy, on your proportionate contribution to that particular need. Our submission, it was our submission before Miss Justice Holgate below, was that you need to do what the examining panel were doing and what ClientEarth was submitting and saying, what is this contribution? There is still a need for this type of development, but what is the actual capacity and contribution of this particular development to that need? That need cannot be, as your Lordship puts to me on the premise, the need cannot be static because consents are being given and this, as the policy goes on. And they're being given to meet a need. So it's a fallacy to say that the need always remains the same.
The question may boil down, or the ground one question may boil down close to this proposition, may it? When we look at paragraphs, I think in particular 419 and 420 of the decision letter, do we find within that passage of the decision letter a proper application of paragraphs 314 and 323 of EN1 properly construed?
Well,
that's wrapping quite a lot up.
Yes, it
into
is.
A single proposition, but it does, I think, crystallise the current debate. But no doubt we're coming soon to look at the decision letter.
My Lord, yes, I'm coming, but my Lord, I'll try and respond to my Lord's question when I go through it, just so I process it, because I think there is quite a lot in it. My inclination is to say yes, but I just need to, it is quite a lot, your Lordship's wrapped in.
It's a caveated yes.
Yes, caveated yes, just. So in terms of the Act, on the 2008 Act, my Lords, there's nothing I wish at this stage to add to it.
Right. So where are we going next?
Well,
policy or the decision letter?
Sorry, I'm going to the decision letter. Just before we leave the bundle, I haven't got, other than we just have the Climate Change Act 2008 target for 2050, the carbon budgets, which are referred to in the MPS and which my learned friends rely on in part of the greenhouse gas emissions, we just make the point that the carbon budgets are specific to the Climate Change Act, and that is a mechanism the government are using in order to measure that act. In our submission, that does not mean that greenhouse gases cease to be a material planning consideration. And I think the argument my learned friend Mr. Strawn makes for the interested party and made in the court below was, well, we're told that they're not to be measured against the carbon budget, and therefore really you can't then measure them, and therefore that supports the argument that you don't take them into account. And we submit that that's a flawed submission. The fact, and we'll see the MPS, EN1 and EN2 talk about it, the need for environmental impact assessment, assessing CO2, but not for the purposes of applying a carbon budget, does not undermine, we submit, our principal submission that greenhouse gas emissions come into play, both in the policy, and if we're wrong in the policy, they come into play under 1047. So, my Lords, I think then I can leave the statutory bundle, go to the decision letter, and in fact, it may be useful, my Lord, if I go straight to the decision letter and also go to my grounds, if that's convenient to your Lordships have indicated.
Supplementary bundle, sorry, core bundle 2, tab 6.
My Lord, yes. That, and your Lordships have our skeleton argument,
yep.
Which is So I make a point that doesn't go to the law, and your Lordship would say is a forensic point, but it's a point often taken against claimants when challenging decisions, that the approach advocated broadly by ClientEarth as to the meaning and application of the policy before the examination of the public was essentially, not entirely, the approach adopted by the expert panel. So whilst I fully accept that an expert panel can err in law, it's often, when one's looking at the context and understanding of policy, said by respondents, these were an expert panel, and you read their decision letter in accordance with that level of expertise. I make the preliminary point, when we're looking at a disagreement by the Secretary of State with the expert panel, and look at the degree of the extent to which the Secretary of State has adequately set out and explained, either by reasoning or logical thought process, the reasons for disagreeing with the examining panel, it is in our submission relevant to note that she was disagreeing with an expert panel that had heard detailed evidence. It's also relevant, and of course the interested party isn't bound by it, but the interested party's case before the examining panel was that greenhouse gas emissions were in play. That was a matter, that position, as my learned friend Mr. Strong confirmed to Justice Holgate in the High Court, was a change in position in the High Court as to their legal submissions as to whether or not greenhouse gas emissions were in play. Entitled to do that, but we say does set the context, and what we say is the interested party was right before the examining panel on that point alone, as were the examining
This is
authority.
not a reasons challenge, Mr.
No,
Jones.
my lord.
So your points about has the Secretary of State adequately explained why she disagreed with the expert panel is that on a ground that's open to you, is it?
It's not a ground in terms of reasoning, but if we are looking at the approach and whether the approach was lawful, inevitably one has to look at what the Secretary of State said, and
She's either right
or she's wrong.
She's wrong.
Yeah.
You've got two expert bodies. You've got the panel on the one hand saying one thing. You've got the government legal department stuffed to the gunwales with civil servants on the other hand. One of them right, one of them wrong. The question is, which is it?
Yes.
Right, one might add to that, Mr. Jones, this, mightn't one, that it's
It
not
could both be wrong as well.
Yes.
I'm so sorry.
Sorry, my
I'm
lord.
cutting.
Sorry.
Forgive me. There's this point too, isn't there? As I understand it, you're not suggesting that the decision letter is in error in its characterisation of the panel's conclusions, where they're recorded or summarised.
My lord, right.
So we don't. Do we actually need to look at all at what the panel said? Once that's accepted, and it's not a reasons challenge, as my lord points out, we're just looking at the decision letter, aren't we, to see whether it's compliant with the proper interpretation of policy.
My lord, yes, I wasn't going to take your lordship to the examining panel's report.
Right.
All I was simply, well, I've made my point in terms of the reasoning. Just on my Lord Justice Lewis's point, yes, it may not even be a complete choice between them being both entirely right or entirely wrong, and that cuts all sorts of ways. So in terms of, if your lordships can also have as well EN1 to hand, as well as the decision letter, and also our skeleton argument, which I know your lordships have.
Remind me, where's EN1?
EN1, my lord, is in a supplementary bundle, tab 2.
Yeah.
2.
Thank you.
And a lot of the, I mean, it's and a lot of the submissions are, although the policy is quite lengthy, and one wonders precisely, yes, whether it could be better drafted. The key aspect that a lot of submissions, as my lords have realised, revolves around Part 3, and which is headed the decision-making process. However, and of course, as all advocates would say, it needs to be read as a whole. So far, then, as the Secretary of State's decision and the court's decision, could I just map out then just some key headline figures, submissions, first of all, before going to the decision letter, as to those aspects where we are in disagreement with the High Court's interpretation of EN1 in upholding the decision letter. So just to flag up, and I think it may all end up being combined in my Lord Justice Lindblom's proposition that he put to me, but we sort of identified really 4 elements. We disagree. There's a difference between us in respect of the assessment and weighting of an individual project's contribution to need. But contribution to need we put in quotation marks. We also appeal against the High Court, or we're at odds with the High Court's interpretation of EN1/2 in respect to the assessment and weighing within the policy of climate change impacts. Now, climate impacts is obviously greenhouse gas emissions, but it's the whole element of lock-in, carbon lock-in, and those factors that are associated with climate change, and which we say the overall thrust of EN1 and 2 is dramatically to make a shift. The third point is we disagree with the High Court's application, obviously, of 1047, and I'll come to that again. We think we agree, we'll come to, because it may be a subject of debate, the apparent acceptance by the High Court and of the respondent interest, that some form of assessment of the project's contribution to need is required, and that assessment should inform weight. So in other words, when we come on to the policy, when looking at the development, the level of weight to be given to its proportionate contribution can go up or down. It's not just one way. And we disagree with what seems to be suggested by the respondent and the interested party as to whether there is this floor of substantial weight. So in other words, the only way is up. And we say that's also to confuse 2 things. It's to confuse the policy's identification of a qualitative need for certain types of development, which the policy then says, as we'll come to, sets out the different levels of urgency and scale, and it confuses as well the requirement of the policy when you come to the actual development to assess correctly the proportionate weight to be given to the particular project. So developing on that, we think, notwithstanding the position adopted by the respondent and the interested party, if one just goes to the judgment, but briefly, but when applying paragraph 3.2.3,
We're getting too many bundles open at the same time.
I'm sorry.
I've got the decision letter.
Yes,
I've got
EN1.
the EN1, and now you want the judgment as well.
Could I go to EN1 first then, my lord, because
Yeah.
we're looking at 3.2.3. Your lordship's quite right. And this is the paragraph I think my Lord Justice Lindblom referred me to a moment ago. And this is this part. It's halfway down. It says also shows why the government considers the need for such infrastructure will often be urgent. We just briefly pause on the word often and highlight it because it won't always be urgent, as we can see in the rest of the policy, because there's different levels of urgency. And the IPC should therefore give substantial weight to considerations of need. But that needs to be read in the context of the next sentence. The weight which is attributed to considerations of need in any given case should be proportionate to the anticipated extent of the project's actual contribution to satisfying the need for a particular type of infrastructure. Now, the approach we say adopted by the respondent and the interested party would inevitably follow that on fossil fuels, you'd be saying the bigger the better. And the bigger we've got, we're making a bigger contribution for the need for fossil fuels. And the only way is up, and it goes up. We say that's the wrong approach, and we emphasise the fact that you have to look at any given case, you have to look at the anticipated extent of a project's actual, and again we emphasise that, to satisfying the need for a particular type of infrastructure. And we submit to your lordship, as I've submitted already, that that is looking and demanding a quantitative analysis as of the time of granting consent. And we don't shy away from the fact, which is relied on incredibly heavily by my learned friends, that the policy says it doesn't set any limits or targets, but nor could it at that stage, because this is a policy that is expected to be evolving towards a dramatic shift in low carbon, during which there's a transitory period when there will be a need for some degree of fossil fuel. But you then need to look at that, the particular development in the way that we've said at 3.2.3.
Why do you say it has to be a quantitative analysis? Where do you get that?
It's from the word actual contribution to satisfying the need.
Yes, but that's the basis for my question.
Yes, well, it may not be the answer, but it's the answer where I get it.
All right, so it's from.
It's one of the. That's the.
You deduce from those words, and it is from those words.
Yes.
That it must be, as you put it, demanding a quantitative analysis. But that's the source of the submission, is it?
I think your point is that it's open to the decision maker, in effect, to say, well, we've got enough of those already. We don't need any more.
Exactly, my lord.
Whatever those are, I mean, there's a particular type.
Or you're too big for what we now need. We need that type, but you're too big. You're not it. So that's why I think it can't be just it can't be qualitative in the abstract, because of this is my submission of why I say quantitative. It may not matter whether it's qualitative or quantitative, but trying to make sense of it in a practical way and what you actually do with this policy is you actually look at what is the actual the need for a particular type of development. And these needs, as I've said before, must be ongoing and changing, because otherwise we must presume that the policy is intended to succeed.
Yeah. Can I just pick you up? I don't want to catch you out on particular words that you've used, but I just want to be absolutely clear what you're submitting to us. Do you submit to us actually that it could be qualitative as opposed to quantitative?
My lord, it could be, but my primary submission is trying to make sense of it, that it's whether I'm using the right label or not, it's looking and seeing, have we got enough, or does this actually, how does it actually contribute to what the actual the actual need is, this type of infrastructure at the time. I've said that that's quantitative, but it could be qualitative. In essence,
to help you with what I've got in mind, so that you know what you're answering. I mean, when we read this document, you've already pointed out that it's lengthy. It's clearly all-encompassing to the extent that it covers a number of different types of infrastructure. It contains a number of statements about the market-led system. It contains a number of statements about the difficulty of making projections, the uncertainties involved in all the variables looking ahead. I mean, that's a very generalized way of describing it, but I hope a fair characterization of the document as a whole. So within that context, might it not be possible, as I think perhaps your submission acknowledges, for the decision maker to take what could be described as a broad qualitative view of contribution, rather than merely, as it were, an attempt at an objectively calculated assessment of quantitative need?
That wouldn't be my submission of no. I think the answer would be no, because of the wording but principally because of the wording I've just.
Well, what kind of qualitative assessment would you contemplate then?
I suppose my primary submission is that the assessment that must be carried out is along the lines of what I've said. I've characterised that as quantitative. But if it's qualitative, it's not because I'm saying the assessment should be different, it's because I'm using the wrong words. That's what I'm saying. My submission on the wording of this policy is that it requires a decision maker to give a consideration and weight will be tied to the proportionality, to the anticipated extent of its actual contribution. So you need to look at it. And with proportionality, if you take proportionality in our submission, you've got, in order for the ends to justify the means, you've got to have an ends in order to justify to know whether it's proportionate. And so that's why in my submission, I've characterised it as quantitative. I mean, the policy doesn't use any of these phrases. They have occurred, and I think my Lord Justice Limbaugh has used one of the judgments, and it may have been in response to submissions, but the policy doesn't use these terms. But we submit, and we say it's in essence out of the actual given case and proportionality. You can't apply proportionality without. One doesn't need to get into different, EU human rights. Proportionality, as understood under English law and policy application, is all about the ends and the means and the proportionality. And you've got to have, in our submission, some quantitative assessment about that. Is it proportionate for me to fly to Edinburgh because I've forgotten my papers at X cost and X carbon? I've got to know the figures, and I've got to know how important it is for me to have my papers for court today. Or should I send a courier?
Yes, the question then might be, and I'm not asking you to answer it, how important is it for you to be properly prepared to appear in court?
Yes, people have often asked that question of me.
But I mean, the point of the question, it's not a facetious question.
No.
It's about what might be described, and we perhaps detach ourselves from the language of quantitative and qualitative, it's perhaps, if you like, in common English, described as an important factor that I have to give serious consideration to. I can't put a value on it, but I know it's important. Now, is that kind of, if you like, broad assessment ruled out by the last sentence of 323?
Well, when it's ruled out, it's not the starting point. You can obviously only make an assessment to the extent to which it's possible to make an assessment.
But I think you're saying that need is not static. Need evolves. Need evolves partly because projects are implemented and therefore electricity generating capacity increases, whether it's renewables or fossil fuels or whatever. On the other side of the line, part of EN1 is a policy to reduce demand for electricity. So demand for electricity may diminish if that part of the policy succeeds. So there isn't, so to speak, a static target at which, at which the decision maker is trying to hit. And the decision maker must therefore ask herself, what is the need for this kind of, this particular method of electricity generation? And having answered that question as best she can, what is the contribution towards that kind of electricity generation that this project makes, or can be expected to make?
Well, my lord, in terms of the policy, I think the policy's aim is not necessarily to reduce energy. It needs, in fairness, it's to reduce
that's what it
carbon.
Says. That's what it says at 3326.
Yeah.
Part of the policy.
Yes.
It's to reduce demand.
To reduce demand, yes, and yes, to reduce demand. That is right, and also to reduce, the carbon-based fuel generation. And I went to, the passages are all there. Your lordships have read them and see the game changer that it's trying to achieve. In terms of the, and I'll come to this on ground one, the types of the need for different types of infrastructure. That's set out. So at the moment, we accept, we've never challenged, that there is still a need for fossil fuel for the transition period for backup. But the question then where we say the actual, whether it's capacity or whatever, is it isn't static, it's changing. So to give another example, there may be a need, and it's a significant need, for school swimming pools across the country. And we've got a chronic shortage of school swimming pools, very important for health, all of that. So whatever the environmental consequences of heating water and all of that sort of thing, there is a need for that. Which is that need is something for which the generic need is given great weight. I then come along 5 years into the policy, after 90% of the swimming pools have been granted consent and been implemented, with a massive Olympic-sized swimming pool. And in looking at, there's still a need, of which generically has considerable weight, for swimming provisions, but you look and see what is the actual contribution of this Olympic-sized swimming pool to that need. And I'm just keeping it in rough terms. It could be location, and it's far too big. It's more than what's necessary or whatever. And that's what we say. That last sentence is because, as my Lord Justice Limbaugh said, all of these factors are difficult to predict. But we know the target. We know that seeking to reduce demand, massively reduce carbon-based fuel production, and move to renewables and nuclear and etc. That is why we say then that this 3.2.3, you've got to then carry out it, and you can't just generically say well, we needed it 5 years ago. There must still be a significant need, and that's it.
All right. Well, I think we've got that point.
Can I just ask two short questions? The anticipated extent of a project's actual contribution, the anticipated extent, wouldn't that be the anticipated output, the amount of electricity that you're going to get from it?
Yes.
So you'll look at that.
But that's only half of it, my lord.
Yes, I know, that's why I said there were
Yes.
two questions.
Yes.
The first
Sorry, yes.
question is anticipated extent means the output.
Yeah.
What electricity you're going to get from it.
Yeah.
And then I wondered whether a project's actual contribution means, is it likely to happen? Is it actually going to happen rather than amount? So is that what it's getting at? How likely really, or is there any reason to think it's not likely that this is going to come on stream? Is it really requiring you to go through the exercise of asking again, how much?
I think it is, my lord, and I will, without repeating it and reading the sentence as a whole, this is all in the context of the overriding point that the question that's being asked, weight in any case, should be proportionate. So the weight to be given is proportionate, and that's the thing you're asking, and it's to the anticipated actual to satisfying the need for a particular. So it's the two elements, and that's why in our submission you can't do it in the abstract. Now, the actual contribution is whether, I mean, there's no suggestion there's a difference between theoretical, but obviously if you had something that what you would expect its actual to be honest, you'd expect the policy, if it's saying its contribution, there should be no need to put actual in to say, as opposed to theoretical contribution.
My point is the actual qualifies the contribution. It doesn't qualify the need. It's not the actual need. How much is left to fill? It's looking at the anticipated extent, which you know, of a project's actual contribution.
Yeah,
So it must be, or is it? I don't know. Looking at whether it's likely to happen. Is it realistic in the sense of actual?
My lord, I'm prepared to accept that if you're looking at a development that is supposed to be fulfilling a need, it's relevant to look at whether it's actually going to happen or not. Otherwise, it's otherwise. I mean, and actually, it's a point I would take in favour, because if you're my lord is right, and I say it must be implicit that when you're a decision maker and you're granting consent in an area to meet a transient need, and that's how it's expressed in the policy. You must be satisfied, even without the word actual, that this is likely to come on and be operational. Indeed, the times of operation are actually quite significant in these cases when they're going to come on stream and what their contribution. I have 2 points. One, it doesn't follow in my respectful submission that you can then ignore the proportionality test and say you don't actually look at what the actual need is, because the word actual doesn't appear in front of need. Because in my submission, I won't repeat what I say on proportionality, you can't make sense of proportionality if you only had one and not the other. The second point I would also make, however, is we're supported in our submission that you can carry out that exercise as best you can, because although the Secretary of State did say in her decision letter, oh, these things have been granted consent, but there's no guarantee they'll come forward, seems a bit odd if my Lord Justice Lewis is right, and in that sense I agree it is right, that this policy expects you only to be granting consent for things, fossil fuel development, that is likely to come on and contribute to the need. So if you grant consent, the presumption is the decision maker thinks you are going to come on stream. It's not just a theoretical exercise.
I mean, it might be said, mightn't it, that this is if you like, a safeguard against the bigger the better proposition. In other words, it requires one to ground one's assessment in reality.
Yes.
My lord, yes, because You read the policy, it's all about dramatic change. We all know, as a matter of where we are living, the huge changes that need to be made in the way in which we operate our lives in terms of energy, even under COVID-19. We're still not getting there. The grounding in reality is necessary in order for us to achieve that overall context. And the EN is littered throughout with that overarching desire to move towards a carbon low energy production. As my Lord Justice Limbon says, if the alternate submission, which was the IP's approach in the court below, is the bigger the better, we blow a hole in that, because the argument simplified, and I may be doing a disservice to my learned friend's argument, but it's sort of, planning system has almost nothing to do with controlling what types of infrastructure comes forward. It's just facilitating all of these types: renewables, nuclear, fossil fuel. And you look to ETS, and we'll come to this later, and the market. So what that then needs, if that's right, and this is that the interested party, well, the bigger the better. During this period, you'll be granting as much fossil fuel as you can. And that gets into the issue of climate change, climate lock-in, where the market will never be able to adjust and respond if you're just granting the bigger the better, in terms of there is a need, and the need is equal, according to the submissions of my learned friend, for renewables and nuclear as it is for the backup fossil fuel under this policy. So in our submission, we do say it's important to take the interpretation that we advocate in order to stop the bigger the better for fossil fuel, and effectively to just blow a hole in the overarching nature of the government policy expressed in EN1 and also elsewhere. But so.
Well, now, Mr. Jones, it's 10 to 12. We haven't yet looked at the decision letter.
Yep.
There's quite a lot to get through.
Yes.
So I think we need to move on. I'm sorry that we have detained you by peppering you with questions.
Well, we've dealt with a lot of the issues that I'm going to come to my grounds anyway.
All right.
So,
so where are we going next?
sorry, can I just take... Yes, so, my Lord, in terms of the approach adopted by the Secretary of State, if I can take, we put away EN1, just a decision letter now, please, and our skeleton argument.
Yes.
And the matters that we so if I can take your Lordship to the conclusions at 144, section 6. And at paragraph 6, the Secretary of State sets out her approach under 104.3 in 6.1 to determine in accordance, except to the extent one of the exceptions applies. He then refers in particular to 104.7, which is our third ground, needs to consider the impact of any proposed development and weigh these against the benefits of the scheme. So what the Secretary of State has done, 6.1, needs to consider whether proposed development is in accordance with EN1, and then you go back, paragraph 4.4, the Secretary of State disagrees with the panel and saying, has not applied the policy presumption in favour of granting consent for energy NSIPs as set out in EN1 when determining whether development was in accordance with the relevant MPS. The Secretary of State considers the development should benefit from the presumption because there are no more specific or relevant MPS policies which indicate that it should be refused, and therefore it accords with the relevant development plan policy. So the reasoning is then for that conclusion is one has to go back to 4.4. And there, the Secretary of State, and it starts at 4.4, but and 4.4, the battle lines are set out was the examining authority's view that there were two relevant issues. Whether there was a need for the development was a matter before the Secretary of State, and if so, the individual contribution would make to meeting identified need. And the examining body concluded there's a distinction between the need for any energy nationally significant projects in general and the need for any particular development, and the former doesn't support the latter. That's an area where obviously the Secretary of State departs, and the Secretary of State one then sees that one can go to 4.12. Secretary of State considers that the gas-fired station would be carbon capture ready. It's a type of infrastructure covered by EN1, and therefore there is a presumption in favour of granting consent. So the Secretary of State, in our submission, simply takes the view that if you come within one of those types of infrastructure identified in the EN1, you benefit from the presumption. And that presumption, the Secretary of State applies whether you're fossil fuel, whether you're renewables and or nuclear. And then at 4.13,
do you say that's wrong or not? You accept that that is what the policy says?
we accept that the policy sets out a need for generic types of development, but we don't accept that the urgency and scale is the same for each of those different types.
But does that come in under the paragraph of EN1 we've just been looking at, 323?
Well, my lord,
because what she quotes in 411 does seem to suggest that her conclusion in 412, that stage in her reasoning in 412 is correct.
Yes, but Lord, I think although there could be arguments to the contrary because of the way the policy is expressed, that the first generic sort of assessment for the weight to be given to the different generic types is that, and she's correct in that at that stage.
Right.
And so the scale and urgency, it's not the most felicitously expressed as to where the scale and urgency comes into, but it would be our submission that comes in when you're looking at the proportionality, because it's the only way you can,
right. No, I understand.
You can, apply it. But I do accept when you look at the policy, it's not written as clear as it might have been, but that's the only way to make sense of the scale and urgency, which the policy says is set out following the generic statement.
Right.
Yes, so the Secretary of State then, it's then at 413, the Secretary of State believes that sustainability, and all other matters of safe, secure, affordable, increasing have all been taken into account. Therefore, this she then concludes halfway down, required makers to go beyond the specific and relevant policies they contain to assess individual applications against those high-level objectives where there is no need. This is where we say she goes wrong. In essence. And then when criticising the examining panel at 14, she says, despite concluding the presumption in favour of fossil fuel generation applies to proposed development, the Secretary of State must consider whether more specific and relevant policies clearly indicate that consent should be refused. As indicated that there will be significant adverse effects of greenhouse gas emissions. The Secretary has considered those arguments. However, in line with 413, and we go back to 413 where we say she went wrong, the development's impacts on decarbonization must first be assessed by reference to specific policies contained in the relevant MPSs, reflect the appropriate role of the planning system, deliver wider climate change objectives, etc. And then she has regard to section 2.2 of EN1, climate change and UK's greenhouse gas emission reduction targets being taken into account in preparing the suite of energy MPSs. So in essence, the key area where we say she goes wrong is at 413, and the rest of the reasoning follows 415 into that, so that she then goes on to 416, where she says that whilst significant adverse effects of the proposed development on the amounts of greenhouse will be emitted to the atmosphere, the policy in the relevant makes clear this is not a matter that should displace the presumption in favour of granting consent. So it doesn't matter how much greenhouse gas you have, the presumption is you will get consent. And that is what she says the policy has determined. And we know she's rejected at 413, having to actually go through what we say is the proportionate assessment of what is the actual contribution this development would make. And so in 417, she says the carbon impacts don't lead to the conclusion it's not in accordance with the relevant MPS or would be inconsistent with the Climate Change Act. And then she then says, the Secretary of State notes the need to consider these impacts within the overall planning balance to determine whether the exception applies in this case. So just pausing there, it appears to be there, we don't say that she does it, but an acceptance that even if we're wrong on the policy, the Secretary of State seems to be accepting the argument I was putting to your lordships before, that under 1047, you can unwind the policy and have policy off insofar as it treats the weight to be given to greenhouse gas emissions, for example.
Well, is she saying that?
Well, she says the Secretary of State has the need to consider these impacts within the overall planning balance to determine whether the exception test 2008 Act applies in this case. Well, she says what she says there. I'm submitting. It's difficult to think what the purpose of that would be.
Well, she's referring to a planning balance to determine whether the exception test in 1047 applies, and that is it not the test that's inherent in 1047?
It's a balance. It's a planning balance.
Yeah. So she acknowledges that.
Yes, but she said
does it at 4.19, doesn't she? And the question is whether 419 is right.
Yeah.
419 is where she comes back, as I pointed out earlier on, to paragraph 323. You said earlier we must read the policy document as a whole. We must also, of course, axiomatically read the decision letter as a whole to see the full analysis.
Yes.
It may not be set out in a particular sequence that might be the best sequence, but the question is, does it properly deal with everything it should in the right way? I say in the right way, on a proper interpretation of the policy.
No, I accept all of those
Yeah.
those points.
So we need to see it as a piece rather than disassembling it and looking at particular parts of it.
No, I accept that. I mean, obviously, it's inevitable in some sense you go to paragraphs and of course, but I accept, of course, must accept the proposition. You read the decision as a whole, and your lordships will form a view on the extent to which it cogently hangs together or not.
I mean, it may be, and I don't want to attempt to cut through absolutely everything on ground one with a single question, but coming back to the question I did ask you earlier on, when you look at 419 feeding into 420 as it does, can the assessment undertaken there properly be described as falling within 323? Whether you characterise it as qualitative, quantitative, or some other word. That's the question, isn't it?
My lord, yes. And my answer is what it was on a preliminary basis before. No, she hasn't done that and hasn't correctly applied it in 419. She, as she says there, having posed the question or noted paragraph 3.23, she then says, this is her answer, and the word therefore is considered whether in the light of the examination authorities find there is any reason she should not attribute substantial weight to the development's contribution to meeting this identified need for CCR fossil gas in this case.
Isn't she firmly locked on to the 323 considerations there?
Well, my submission, no, because what you've got to do is apply it. It's not a sort of departure. Are there any reasons why I should depart? You're looking at assessing what the actual contribution is.
That's right back to the question as to whether the benefits of the proposed development are what the policy says. A substantial contribution to the need for energy from fossil fuel. That's what the policy says the identified need is. And isn't she simply saying, is there anything to suggest that adverse impacts outweigh that?
Well, I think adverse impact is dealt with later on.
Yeah, I don't think that. I don't think that's
any reason why she should not take the policy the defence as described.
This paragraph here is not talking about the planning benefits and disbenefits.
3.23. That's fine. Don't worry about that.
Right. Okay.
But isn't she really saying? Is there any reason why she shouldn't give
Well, that's what she
substantial
says.
weight? But what's wrong with that?
No, well, you apply the policy. The next question is a direction. What I would say is you've got to read the policy as a whole. When you're looking at the policy of what weight you give to this, at the end of the day, this is an application for development consent for a specific project. And the policy tells you that notwithstanding that the generic policy approach for certain types of development is that they should be given a substantial, significant weight. Yeah. So, but then it then says, but then when you go on to look at the development consent, so you can't come along and argue you shouldn't generically give any weight to nuclear energy because we object to nuclear energy. You're challenging the merits of the policy, subject to the arguments on this. But when it actually comes to looking at the actual overall weight you give to the particular development, you don't just go substantial weight because it's a type of development. Is there any reason to depart from it? You've got to go on and actually assess its contribution. So,
but she would say, forgive me, Mr. Jones, she would say, and it may be said on her behalf, that that's precisely what she purports to do in 419 and 420, because 420 provides the answer to the question posed in 419. It provides that answer, it may be argued, in the penultimate or the pre-penultimate sentence of that paragraph. And what intervenes constitutes, it may be said, the assessment required by 323. And that is really the point I think you have to confront.
Well, our submission is that it doesn't. If you look at 420, actually assess what its actual contribution will be to the need. The first thing is the evidence of other consents may have place. She says there's no guarantee they may reach completion. She goes back to EN1 up to energy projection, so that's not looking at what is the current need for this type of development where we are. Just and says and just quotes, doesn't reflect a desired or preferred outcome for the government in relation to the need for additional generating types of electricity required.
In a nutshell, I think your point is that what the Secretary of State is doing in 420 is considering the question at a theoretical level, whereas the panel have looked at it at a practical, actual level, and that reflects the instruction in 323 to look at the actual contribution. And the Secretary of State's exercise in 420 is entirely at the theoretical level, looking at different bits of policy, without actually asking, well, what's happening on the ground?
Right, Lord, yes.
That's the point.
That's it.
What's the point of having, as a starting point, you've got this national policy, you decide you do need energy from fossil fuels, and that you should give substantial weight to things that contribute to that need. It seems odd to say, well, we'll put that to one side. We won't start with that and see whether or not there's anything that causes us to doubt that that's a proportionate approach. And we'll start again by assessing whether or not there is a need and whether or not and to what extent the project does do it.
My Lord, no. And for this reason, first of all, as my Lord Justice Lindblom said, you set out the policy at the beginning. This policy was made by the then coalition government with various objectives to make the sea change to low carbon. There are all sorts of things when you read through it. I mean, it's quite a verbose policy, if it can be called a policy in all respects. Some aspects don't seem to be policy, but statements of intent, what they hope to be doing, how they hope to, all different descriptives, dealing with all of that. But the key thing was, where are we starting from? Where are we starting from? Where are we aiming to get to? But we're starting from the date of the publication of the policy, obviously. Where are we aiming to get to? And we've got the various targets set out. We've got specifically in terms of dates, and also the target of sea change, dramatic change to low carbon. Identification of the need for fossil fuel during a transient period within the lifespan of that policy. So we must begin on the submission that the proposition that this policy is intended to succeed in what it's doing. As it succeeds and as it goes along, whilst a generic need will stay, so for example, there is still a need for nuclear power, very controversial, let's take another and that's set out. There is a transient need, and it's expressed, you've got our submissions on, I can go through them, but you won't, on the transient need for fossil fuel for meeting which will needs as renewables become more sophisticated, more lengthy in consent. So the notion that the position at the beginning of this period might have been a bit more straightforward for fossil fuel. Because at the beginning, there's an obvious need, and the same as it is at the moment for renewables. At the moment for renewables, and a point is made supposedly against us, that the one side, the bigger the better, would fit renewables. Well, it only fit renewables insofar as we still needed them to go to in those quantities to get to our low carbon target, which is set out in the EN1. So it isn't, in my submission, it would be shocking the other way if you have a policy that is designed to move by 2050 to this dramatic change, that as you go along, you just ignore the realities of what's happening and carry on as if you're on day one of the policy. And that's why you've got to look at the actual and proportionate contribution in our submission. And that's the logical and rational. That's the only way it's going to succeed in any event. If you want a policy that's pragmatic and going to succeed, it's not going to succeed in the way it's been presented in a submission. This is planning to fail for all the reasons that the policy sets out, with carbon lock-in and our dependency on a carbon market. We're not going to shift the market if we just have open sesame without regarding any regard to the actual contribution to those particular needs. So there is a category of infrastructure that is needed, for which there is, in principle, significant weight. As things go on, the actual developments, although you have to measure them by what actual contribution they make to that overall need. And as the need quantitatively, I've used it as time changes, that contribution and proportionality changes. And as I say, on the meaning of proportionality, in our respectful submission, one can't apply proportionality as the Secretary of State does in a theoretical sense.
Yeah, you say as the facts evolve, so the application of the policy has to evolve.
Yes. So if, for example, going back to me going to get flying to Edinburgh to get whatever papers I need for today, if just looking on proportionality of cost, if the cost of the flight is £50, that's different to if it being £1,000. If the price has changed, the contribution changes. You can't then say, is it proportionate? The need hasn't changed, but the cost has changed. And you can only measure proportionality by assessing need and cost, or means and ends. You can't take one of them out and then apply proportionality. And we say that's what the examining panel were trying to do. May not be an easy task to do, but you can't cop out, as the Secretary of State does, and effectively just write out chunks of the policy without any application to the reality.
Right. Well, I think we've got that point.
You've got that point, my lord. Ground 2 then is on the role and the assessment of greenhouse gas emissions, which we've touched on. And the difference between us, and I'm on page 15, my lord, of our skeleton argument, paragraph 32.
Yes.
And the grounds 1 and 2, there may be a degree of link in success, depending on which way your lordships go. But at the heart of our submission is whether greenhouse gas emissions would of themselves be sufficient to override the presumption in paragraph 4.1.2, which is the finding at paragraph 171 of the High Court. And of course, the first thing is, not all presumptions are irrebuttable, and the question is the potential harm, which is set out in the findings of the examining panel and accepted by the Secretary of State in terms of greenhouse gas emissions, something that cannot shift that presumption. And the key issue we submit in understanding this is to look at paragraph 5.2.2 of EN1, and the same passage essentially is at 2.5.2 of EN2. and it turns on the passage we've underlined. It's CO2 emissions. So obviously CO2 emissions are not the entirety of greenhouse gas, but they are the sort of core, one of the most proportionate elements of it. And it's recognised that the significant adverse impact of some types of energy infrastructure, of which this particular one is, cannot be totally avoided. And then it says, however, given the characteristics of those and other technologies, note in part 3, in the range of non-planning policies aimed at decarbonising electricity, such as EU ETS, just pausing there, as your lordships will be aware that what will happen after the 31st of December is another matter, but the EU ETS scheme is an EU wide scheme, and it's not limited just to the energy sector. So and it is obviously as a non-planning policy. So that's where you trade emissions across the EU. So the government has determined that CO2 emissions are not reasons to prohibit the consenting of projects which use these technologies or impose more restrictions on them. It then talks about, which we also refer to, any environmental statement on air emissions will include an assessment of CO2 emissions. And this is where the policy needs to be read very carefully, because the policies will, but the policies set out in section 2, including the EU, apply to these emissions. Now, pausing there, an environmental statement, as we see, is the environmental statement that needs to be carried out for development consent to be granted, and has to be taken into account when you're considering whether to grant development consent. It's got nothing to do with EU ETSs. Your emissions trading depends on what you pay for it. You'll need your development consents in your various countries, but the environmental statement does not impact directly on EU, because it is focused on the development consent process, as we'll see. Then it says the decision maker does not therefore need to assess individual applications in terms of carbon emissions. Now, my learned friends would have it stop there, but it doesn't. It's against carbon budgets, and this section does not address CO2 emissions in any emissions performance standard that may be applied to plant, which that's, again, to do with permitting. But there is the acknowledgement, which we'll come to in a moment, but that CO2 emissions have to be included within an environmental statement for a development consent project. And our submission is that you must read the policy so as to accord with European law. And what we say, and it's in paragraph 34, is simply that the reasons they're not reasons to prohibit the consent of projects. It's simply the statement of the generality. This policy is dealing with generality in terms of the significant contribution of different types of development. So we submit that properly read, what this means is you don't simply reject, nor could you, fossil fuel because it produces CO2 emissions. Those can't just simply be the reasons, a generic reason for refusing. And we know that because the policy accepts and concedes that there will be a need during a transition period for this type of development which has fossil fuel, which, as the wording says, inevitably, even when you limit it, has some CO2. So as we say at 34, you couldn't come along unless you want to depart from the policy and say, I object to this development because it produces fossil fuels. That blanket submission But we do say that it does not mean that when you've assessed the particular level of CO2 emission, that cannot be a reason for refusal, notwithstanding the wording in that policy. When you look at the particular development, and that is because, we can, if I can just go to the statutory material on. It's reinforced, I should say, by what we say on the directive, which is directive and regulations, which is expressly addressed in the policy, and which your lordships will find the regulations in the statutory bundle. The directive is at a 58. Sorry, is at tab 5. And the domestic regulations, which we can do, it's at tab 6, which is the regulations that apply specifically. They're not the general EIA regulations, but those that apply to infrastructure planning, and that's seen at page 93. And then if one looks at the definition of environmental information, which your lordships will see at page 95, which means the statement, well, I won't read it out, but would include, as the policy acknowledges, EN1, EN2 acknowledges, CO2 emissions. And then at regulation 4, prohibition on granting consent without consideration of environmental information, and this regulation applies to an order granting development consent for EIA development received by the Secretary of State. So it's common ground, it's not disputed that it doesn't apply, and the Secretary of State had full knowledge of that in terms of policy, not because the EN1 expressly refers to this. And then where this regulation applies, and again it's common ground it applies, the Secretary of State must not make an order granting consent unless an EIA is being carried out. And then there's a requirement, regulation 21, page 98 at the bottom, when deciding whether to make an order granting development consent for EIA development, the Secretary of State must examine the environmental information, and then your lordships will see B, reach a reasoned conclusion on the significant effects of the proposed development on the environment, and then taking account of, and then C, integrate that conclusion into the decision as to whether the order is to be granted. So our submission is that one must read the policy first blush on the intendment that the Secretary of State or the author of the policy was not intending to break domestic and EU law. We've not pleaded, and make it quite clear, we've not pleaded in this case that that there is a breach of 104, it may be 5 and 6 on the breach of international law, because we rely on the interpretation on ground 2 that the policy wording, for the reasons that I've just explained and we set out in the skeleton argument, backed up with the presumption that the policy would accord with law, means that whilst it isn't a reason to say, all it is saying is you can't refuse it just because it's CO2. It is not saying when I'm deciding whether or not to grant consent, I can't take into account CO2 or other climate change factors as a reason whether or not to grant consent. I mean, you would have it, for example, and this is, you know, when you look at the benefits and disbenefits under 1047, you could have, let's say there's another equivalent, we're not into this stage, but you could be aware of another fossil fuel development that could provide the same amount of power as Drax, but with half the CO2 emissions.
What you're submitting is that the sentence in the middle of 522, government has determined that CO2 emissions are not reasons to prohibit the consenting of projects which use these technologies, etc., means that there is not an automatic knockout blow.
That's right.
That's the submission.
That's it, and that's yes. And the Secretary of State and the court below have interpreted it to mean they cannot be reasons of themselves for refusing consent.
But I think you were also saying that 522 doesn't address, at least in terms, the scale of CO2 emissions in any particular case.
No.
All it says is, as my lord puts it, that it isn't a knockout blow, that there are some CO2 emissions. The quantity of CO2 emissions likely to be produced by a particular project are still relevant considerations. Indeed, they are required considerations under Regulation 21, and may produce, that would not be contrary to policy for a decision maker to say that the scale of CO2 emissions likely to be generated by this particular plant are reasons in themselves not to grant the development consent order.
My lord, yes.
Yeah.
And that's really the second ground.
Yeah, all right, we've understood that, thank you.
The third ground, I've almost, I've already in opening to your lordships on the touch with. I think probably it may be useful just to take your lordships to some authorities. The proposition that the High Court came to, that greenhouse gas emissions could be taken into account at 1047, but only in combination with other factors, we say is illogical and, well, frankly, bizarre. So, to give us an example, you could, as the High Court ruled, one could have a situation where you have a fossil fuel energy generator which is inefficient or produces lots of greenhouse gas, but is nicely positioned in the landscape, has no real heritage impacts, and that must be granted consent, as I understand the High Court's decision, because you couldn't just refuse it, even on 1047 on greenhouse gas grounds. But then you could have another development that has only half the greenhouse gas emissions and has some minor landscaping harm, and if the High Court is right, it would be open to the Secretary of State to then refuse consent for it. And in our submission, that would be, well, we say that's a misunderstanding of what is a material consideration as a matter of law, and secondly would lead to absurd results. Can I take...
As I think one of your opponents points out, I think it may be Mr. Strawn, we need to be cautious of this phrase material consideration.
Yes.
Because it's a statutory phrase in the Town and Country Planning Act, but not in this Act.
My Lord...
And it's acquired an awful lot of baggage over the years.
Yes. But it's not a phrase that is peculiar only to town and country planning. A consideration may be material or immaterial to a whole host of public law decision-making processes. I mean, there's whole sections in Mr. Justice Fordham's book.
Yes.
I
think they're usually described as relevant or irrelevant. Rather
yes.
I'm just a bit cautious about the word material.
Well, I'm happy to use relevant or irrelevant for these purposes. I mean, I haven't seen, notwithstanding my learned friend's point, any analysis to support what is, I don't want to play on the word, material difference in this respect between the Town and Country Planning Act and this section, other than, and I accept, the difference is, of course, as my lords will know, is under the Town and Country Planning Act, you have section 38(6), and the presumption in favour of the development plan unless material considerations indicate otherwise. And in this case, we have section 1043, which sets, and I actually rely on that distinction to say, when I was making my submissions about some of the submissions about the exceptions, that is the statutory exception for departing from the policy, which may or may not have various presumptions within it. But insofar as whether, and I don't think it's seriously being suggested by my learned friend, that greenhouse gases are an irrelevant consideration, would be an irrelevant consideration he may do, and I'll listen to what he says, in the DCO process, because of some distinction in statutory wording. In terms of 1047, an adverse impact of a development, in my submission, is capable of including its greenhouse gas emissions. That is an adverse effect of the development. And so far as the authorities, could I just, the approach to the presumption and exception, could I just, yeah. My Lord Justice Limbon's decision, judgment, I think, with the support of colleagues in the Court of Appeal in Scarisbrick, tab 9. Scarisbrick, tab 9, my Lord, page 69.
Paragraph
69.
Do you mean paragraph?
Sorry, paragraph 69, page 149. I'm sorry.
Yeah. It's always. Your Lordship will know what your Lordship means in a paragraph, so I always hesitate to sort of then try it with a decision. But
very bold submission, Mr.
We're dealing with obviously the hazardous waste MPS, the waste MPS, which is slightly different, and then your Lordship decides the requirements of 104 of the 2004 Act, which of course is the whole section. My learned friend said. Referred to your Lordship as applying to 104.7, but I think then your Lordship does go on to say that the Secretary of State had to undertake an appropriate balance of considerations weighing for and against this particular proposal, giving MPPS the statutory priority it was due. But all I would submit in respect of that, your Lordship was talking section 1004 as a whole, where of course there is a statutory priority, and then went in as part of that to take an appropriate balance weighing for and against giving MPS the statutory priority it was due, which of course that is the starting point. But if in fact a judge in terms of whether the statutory presumption remains, we do I would take your Lordship's to tab 11, the Spurier Divisional Court decision, and it's from the judgment of Mr. Justice Holgate, and at 192, paragraph 106, my Lords, at A to B, and it's a section rejecting Mr. Humphrey's submission, and says section 104.7 read with 104 104.3 precludes the consideration of alternatives. It's that submissions. He says where alternative, and this is dealing with the alternatives have not been rejected in MPS 104.7, still allows the striking of the planning balance against the development as an exception to the presumption created by subsection 3. And as we've said,
I'm a bit lost. Where are you reading from?
192, paragraph 106.
Oh, 106. I'm sorry.
Sorry.
It said 108.
I'm sorry, my lord.
Yeah.
So you're relying on that?
I'm relying on B. I mean, it's talking about alternatives, and I think it's important to understand that when some of the submissions of my learned friends rely on that. But this is not an alternatives case. I'm simply relying on the recognition that that the 104 is an exception to the presumption created in subsection 3.
But even here it's saying that if the alternative had been assessed as part of the policy, I know it's alternatives and I know the facts are different, but it all chimes with the starting point, if you like, is the priority given by the policy. And the question is there something that should cause you to depart from that?
My lord, no. That part of Spiria, which I cannot say, about relying on the alternatives, that is where we say it goes wrong, and that Mr. Justice Ousley's judgment, when properly understood, it doesn't support what Mr. Justice Holgate is saying there about Holgate. Yeah, so sorry, I make that clear. That first bit we say is wrong, but and we're not dealing with alternatives now, but we do. I know this is cherry picking here, but rely on the recognition that it's an exception, but we don't accept that the analysis insofar as alternatives that they have to be assessed or not, because and I'll deal with that in a moment. But whilst we're on this judgment, could I also refer to paragraph 109?
Incidentally, it is a judgment of the Divisional Court.
Yes.
Not just of Mr. Justice Holgate.
No, my lord, that is this Divisional Court.
Or Justice Hickenbottom and Mr. Justice.
That is right, yes. That is right, yes. 109. This analysis would not preclude the making of an objection in the DCO process. There's been a change in circumstances. This is 109 at the bottom. That there's been a change in circumstances since the designation of an MPS that affects the assessment of the adverse impacts of the proposed development itself and may cause the balance struck under section 104.7 to come down against granting the development of consent.
Well, that exemplifies, or that encapsulates the point that I raised with you earlier on, I think, about the change of circumstances, which might be a change of government thinking on a particular topic.
My lord, yes.
That's consistent, isn't it, with that?
Yes, it is. 109 is one I like.
You like 109?
I like 109. We rely on 109. Just, that's... and we also...
I was a little curious about the reference to Lord Justice Sales in Blue-Green Economy, which, as far as I can see, is a refusal of permission to appeal for which permission has not been given to cite it.
My lord, yes, I just checked, because I saw we've all got it in our bundle, but I just checked with my junior. I could not find, when I was looking at the report, any certification saying that it was an authority.
No, it seems to me that it's just uncitable.
Yes. I'm not going to take your lordship to it.
My lord, if I can just interject, in paragraph 107 of Spurrier, the Divisional Court do cite it.
I know they do. That's why I say I'm puzzled. I'm puzzled by that, because it seems to me to be an uncitable, not quite sure what to call it, decision.
Yes, yes. Well, it doesn't carry the weight of a Court of Appeal decision, and then your lordships will make of it what how it's been incorporated into the reasoning of the Divisional Court, I suppose. But it doesn't carry any weight of...
No. Well, maybe the Journal of Planning Law shouldn't have reported it.
Yes, yes.
I don't think this was live, was it for us in the appeal or appeals? This question.
No, it's not. It's not a point of appeal.
No, no. So it wasn't considered by the Court of Appeal in that case.
Oh, when it Plan B. No. Oh, I'm sorry. I thought you meant this.
Spurrier became Plan B.
Yes, it became Plan B. No, I don't believe it was a live issue before your lordships.
No. There were so many issues. I can't be absolutely
Yeah,
sure.
I'm not. I don't
think
believe.
it was.
Don't believe.
Anything more in the divisional court?
My lord, no, my lord. I just want to if your lordships feel it would be helpful, I just want to take your lordships, if I can, to what I did mention in answer to my Lord Justice Limblom, and also my Lord Justice Lewis, I'd not agreeing with the approach of the divisional court in respect of opening up 1047 being limited by way of reference to the alternatives. And if one could just go to tab 7 first of all. It's the first of all, it's blue-green. Mr. Justice Ousley. And this was the Thames Tideway case. So the MPS concerned the Thames Tideway. That's para 7, 107 of the authorities bundle. That's all it concerned. And then paragraph 8, there were a number of alternatives again considered at this stage, and then quotes from the government's consideration of the
Well, the point here is that the government already decided that the Thames Tunnel was the right answer.
and it's a completely different sort of policy, and what you're looking at is an MPS not for energy generation but for a Thames Tideway tunnel. That's so when you're looking at what you can reopen at 1047. The development of the MPS are two different. It's a completely different thing. This EN1 and EN2 are talking generically about energy policy and then fossil energy policy. It's the equivalent if we had the MPS for Drax and the reuse of the Drax site. So.
So you're going to show us where the Secretary of State got all this wrong?
Yes.
That's the key question.
Go back to Secretary of State's decision. And 144, 145. And we get paragraph 6. 6.2 refers to the examining authorities balancing of under 1047, and I don't read that out. It's been carried out until it's summarised until 6.5, 6.6. There's a difference on the interpretation of the need case.
Well, just pausing. I'm sorry to interrupt you here, but no problem with 6.3, 6.4, 6.5.
Well, she's setting out the examining.
Setting out the, yeah.
And I've accepted that we're not saying misunderstood what they were saying. Or
Right, so the error arrives where exactly?
Well, first error would flow in, obviously, because they say that the examiner, it would also follow, as it happens on 1047, if we're right on grounds 1 or 2, on the application of the policy, it would also infect the 1047 decision, because 6.6, the Secretary of State repeats when dealing with 1047, when looking at the benefits and disbenefits, her disagreement of the need case on the MPS. So if
that takes you back to 419 and 420.
Yeah, it infects it. So,
Yeah.
but that point would be dependent on winning on the other grounds anyway.
Yeah.
So,
To what extent is this ground then not dependent on the others?
oh no, it's also independent as well. That element of it is dependent.
Yeah.
And then the error that we say is essentially 6.7, because it's open to the Secretary of State to depart from MPS policies. Not an error. I don't say that's an error, because there is and then she says give greater weight to greenhouse gas emissions. Just pausing there, that seems to be there, although I'm being. We were told by the High Court that you couldn't give, and we're told by my opponents we can't give weight to greenhouse gas emissions because of the policy, because it says it can't be a reason for refusal.
But well, what do you say? Leave aside what others have said.
Okay,
Mr. Justice Holgate, what do you say about that final sentence of 6.7?
We say it's wrong because it doesn't apply the exception test. What it says, it treats it that you have to demonstrate compelling reasons to depart from the policy. And that's not what the exception says. If it did, it would say it, unless there are compelling reasons to depart from it. It's a very different test. Now, whatever goes into the balancing test and however much it's weighted, and we've debated that, but I've debated that before you, well, I've made submissions before your lordship. Even if I'm wrong on some of that, even if some of the policy gets through, it's not a departure issue. It's weighing up the adverse impacts of the development against the benefits. And that is not what's been done. The threshold has been set is a compelling reason to depart from the policy.
So you say there are two errors here. One is that this isn't a departure from the policy issue at all. It's the balancing exercise that 1047 requires to be carried out. And the second error, you say, is that even if there were to be a departure from policy, the choice of the adjective compelling sets the bar too high.
Yes.
Right. Right?
My lord, yes. I think, my lord, lordships, looking at the 10, those, unless I can assist further, those are my opening submissions setting out the case.
Thank you very much, Mr. James.
Thank you.
Yes, Mr. Tate, you might as well use the 10 minutes or so.
Look, can I start with ground 1 and ask your lordship to look at EN1, which is in the supplementary bundle at tab 2. And to page 44 within that, paragraph 3.6.8. And this is under the heading, the need for fossil fuel generation. And in preceding passages, there is text about these matters, including fossil fuel generating capacity specifically, essentially 368 provides a conclusion to the precedent paragraphs. And 368 provides, in the final sentence, that there is a need for CCR fossil fuel generating stations, and the need for the CCS demonstration projects is urgent. That latter part, I'll come back to, urgency, because that can be relevant, I would submit, in the context of looking at the contribution. But this isn't a CCS demonstration project, nor is it a renewable energy project, where also there are words relating to urgency set out in EN1. This is, however, simply a CCR fossil fuel generating stations for which there is a need established by policy. That's clear that 368 has that effect. And then turning back to page 28 in EN1, and to the sections in my copy, blue box between 311 and 314. And 312, or 311 starts by saying UK needs all the types of energy infrastructure covered by this NPS. And that includes clearly CCR fossil fuel generating stations. 312, it is for industry to propose new energy infrastructure targets within the strategic framework. The government does not consider it appropriate for planning policy to set targets for or limits on different technologies. And 313, the IPC, now the Secretary of State, should therefore assess all applications for development consent for the types of infrastructure covered by the energy MPS, and that, by reference to 368, includes fossil fuel generating, so long as it is CCR, carbon capture ready, on the basis that the government has demonstrated there is a need for those types of infrastructure, and the scale and urgency of that need is as described for each of them in this part. So there's nothing about urgency in relation to CCR fossil fuel generating stations, and nor is scale specifically specified. But nonetheless, it's clear that the government has demonstrated there is a need. There's a policy need for CCR fossil fuel generating stations.
But does footnote 16 envisage that the need may change as the facts evolve?
No, and I appreciate that's a point taken, but that is explaining how the government has reached the MPS EN1 in determining the planning policy, the process it's followed.
Yes,
it makes it clear else.
The last sentence of the footnote.
Yes. Yes, that's correct. But it also needs to be looked at in the context elsewhere in the document, in particular the critical part in part 2, which is setting out the framework more fully, that where it does deal with a number of different projections, that the projections are not intended to be in any form government policy or for that to be read as setting any limits. So if I can just
I follow that, but the point that Mr. Jones was making was that when you come to look at the actual contribution, you need to look at how things have evolved on the ground, so that if the transition to low carbon, which section 2 of EN1 envisages, has succeeded to a greater or a lesser extent, the need for a particular type of electricity generation may diminish.
Well, that essentially would involve reopening the need, and it would be in contradiction of the demonstration that there is a need demonstrated in the policy for CCR fossil fuel generating stations.
So you read the government's statement that there is a need to mean there is and will continue to be a need until such time as this policy is revised?
Correct, I do. And then there's 314 in the last section in the box, that the IPC should give substantial weight to the contribution. So that's a separate matter. First of all, the need has been established. But then under 314, there is the first appearance of the question of the contribution and the weight to give to contribution. So unlike in the Scarisbrick case, which was the NPS on hazardous waste, there was no such injunction in relation to weight. There was a clear identification by policy of a need, which was in that case accepted, not challenged by the panel or by the Secretary of State. But 314 is going on to look at the distinct question of substantial weight, the weight to give to the contribution. And that makes clear, and this is the first instance of it, 314, over the page 323 as well, should give substantial weight to the contributions contribution projects would make towards satisfying this need. So my submission, my Lord, 314 is not reopening the issue of the need, which is settled by the policy, and nor is 323, which is cognate with 314. 323 says in the penultimate sentence, the Secretary of State now should give substantial weight to considerations of need. So it's in the preceding sentence. And that isn't intended, in my submission, to be altered or adjusted by the last sentence. The weight which is attributed to considerations of need in any given case should be proportionate to the anticipated extent of a project's actual contribution to satisfying the need. In my submission, what that is saying is that the contribution in any given case needs to have regard to the other impacts when one is considering that weighting exercise. That's what proportionate means in this context.
Other impacts, what? I mean
Adverse impact.
Adverse.
Yes. So one needs to make sure that the substantial weight, the weight that is being given, is proportionate to the adverse impacts. And as an example of that, if the contribution to which the contribution in question was very minor, it existed but very minor, one would want to make sure that although one would give substantial weight to that very small contribution, nonetheless, overall the balance has got to be struck having regard to the weight of the adverse impacts. In my submission, that's how it that can sensibly operate.
So the language proportionate to the anticipated extent of a project's actual contribution, how does that fit with that, with your interpretation? Because you seem to, are you submitting that it really means proportionate to the adverse impact?
Yes, in my submission it means proportionate to the adverse. It means proportionate to the proportionate in the context of the adverse impacts.
Yeah.
It may not be the most beautifully expressed.
So proportionate, it means proportionate, having regard to the adverse impacts.
Yes.
To the anticipated extent.
Yes. And I would take up what Lord Justice Lewis, my Lord Justice Lewis indicated about the extent of a project that will be the gigawattage in this particular case, 3.8 gigawatts. And the word actual, in my submission, I'm not sure that adds very much here, it may be when one is considering one of the needs that is urgent, because there are some needs, such as the CCS demonstration projects, that are urgent, then the extent to which a project is going to come forward in time to meet that would be relevant, because the need would be urgent and the contribution would need to be assessed against how the policy describes the need. And therefore, if it can come forward urgently, then that is an actual contribution. But otherwise, I'm not sure it would have any particular significance in the context of the policy, which is very much a market-based policy, as evident from 224 of the policy. But I can come back to that.
Yes, you want to come back to that at 2 o'clock. Right, 2 o'clock.
All right.